Hi, this is Dave Reeser with a lesson on Dobbs v. Jackson, one of the most profound decisions of our lifetime. If you're an elder like I am, maybe the next most profound was Roe v. Wade in what it did and what it did to our country over the last 50 years, and what Dobbs v. Jackson is working to do and undo. And so, without further ado, let us go ahead and begin this lesson, and we'll see what Dobbs v. Jackson, what it said, and what it means. First of all, because some of you watching this are not familiar with who I am, I should give you a quick summation. I'm a teacher. I've been teaching American government for 24 years, student senate for almost 22 years now. I'm a writer and author with over 50 books to my credit. I've spoken on a number of subjects across the country, especially in Minnesota. I'm a board member of Human Life Alliance. I was a national campaign manager for Alan Keyes for president in 1996, and I've been an endorsed candidate 4 times for the Minnesota legislature. So I've done a bit of campaign consulting. I am the former chair and president of the Constitutional Educational Foundation and the founding president of the Declaration Foundation. I've been married 55 years. I'm the father of 5 and grandfather of 10. There you are. MoveOn.org in an email May 16th, 2022 was talking about reactions to the leak of Dobbs v. Jackson, or the anticipated leak. I have to tell you, frankly, I forgot the date of the leak. But anyway, it was in May, and MoveOn.org said, this weekend, over 1 million people joined Bands Off Our Bodies marches across the nation. And we should feel hope for a world where everyone has bodily autonomy, except for the unborn. A world where everyone is respected, valued, and is fully protected civil and human rights, except the unborn. After countless attacks on abortion and reproductive rights, people came together to declare that abortion is health care. I heard that a lot during the campaign season, and to demand that our elected officials take action before it's too late. Well, so there was a bit of skullduggery, as you know, last spring when the first draft of Dobbs v. Jackson was leaked to the public. As I'm giving this lesson, we still don't know who did that. It is a terrible, terrible thing that was perpetrated onto the court. It's vitally important. This is about, by the way, as much about how the judicial system works as it is about the decision itself. These justices have the freedom to write their first draft and pass it around among the members so they can review. Justice Alito did that. He passed it around to the members so they could review it, and someone leaked it to the public. So you say, what's the big deal about that? Well, the big deal is that now can the justices honestly share with each other candidly and have candid discussions about the law, because that is the way it ought to be done. It should not be done in secret. It should not be done with justices undermining each other, but having frank, open, and sometimes, yes, emotional discussions about great issues, because after all, they're going to affect all of us to some extent, at least. And so this was a terrible travesty on the court. But they did decide. They announced it on June 24th, 2022. And on the most important point in the leaked version and in the final version, it said it overturned Roe v. Wade. I'm assuming that people who are watching this know about Roe v. Wade. The decision is full of background information on Roe v. Wade and on the Casey decision, Casey v. Planned Parenthood. But Roe v. Wade was the decision that interrupted the debate, the political debate about abortion in the 60s and 70s, and declared that women had a right to abortion based on certain structures that the court devised and put into place. And it overturned almost overnight our politics and so much more. One thing it did was it pinned the label, at least over time, eventually, as more and more Democratic members of their party were unable to run for office if they carried a pro-life label. I believe that in the current Congress, there's only one pro-life member of the House of Representatives and none in the Senate. And frankly, folks, that's impossible in a balanced legislature. Even if all Republicans were 100% pro-life, whatever that means, that would be unusual because there should be some dissent in caucuses. By the way, that isn't true about Republicans. So, and it has attempted to make protecting human life an extremist position. The campaigns that are winding down, finally, so many of them attacked Republican pro-lifers as extremists. And I honestly, the whole idea that you should say someone who's trying to protect human life, even if you don't agree that the unborn child is fully human, which some don't, many will say after a certain period of time, how in the world is it even possible to have that discussion that protecting human life is extreme? Well, what changed? What changed was politics. The election of Donald Trump and the appointment of these three members to the Supreme Court, which tipped the balance from 5-4, 4-5. Really hard to know about Justice Roberts, how he would come down if there wasn't more leverage on him. And it also was affected by the willingness of the United States Senate to, frankly, withhold the nomination of Mr. Garland, who was nominated by Barack Obama and not allowed to go forward, and then pushing very, very hard against many, many odds and a very vicious attack on these three and getting them all appointed to the Supreme Court. Many of us used to say the most important election in our era was every 4 years. It seemed like every year it was getting more and more important, and that was electing a president who would appoint justices. Now, I'm going to say it a little differently than you might think. I'm not going to say pro-life judges. I'm going to say justices who believe in original intent of the Constitution and are willing to interpret it that way. Now, they have to also have an understanding of the innate value of human life and the way that God created us, and the effects of the Declaration of Independence, where we're told that God created life. We're endowed by our Creator, not by some evolutionary process with life, liberty, and pursuit of happiness. They had to believe that for sure, because that's what informs our Constitution. But they had to have this idea that the Constitution says what it says. That's who he appointed. So what was the case about? Mississippi Code 4141, 191, nobody needs to write that down, was called the Gestational Age Act, passed in 2019. And this is from it, based on the findings in paragraph A, whatever that was, relating to facts about abortion and how other jurisdictions deal with it. That's my little insert of this subsection. It is the intent of the legislature through this section and any regulations of policies promulgated hereunder to restrict the practice of non-therapeutic or elective abortion to the period up to the 15th week of gestation. Non-therapeutic, elective abortion doesn't seem to rule on others, and up to the 15th week of gestation. So this would be known as a 15-week bill. Since this decision, there have been other bills passed, even in Mississippi, and I don't know them specifically, but down to 7 weeks or 8 weeks or all together and so forth and so on. But this deals with non-therapeutic and elective abortions to 15 weeks. It is my understanding, and I believe it's correct, that Jackson Health System in Jackson, Mississippi, did not perform abortions after the 16th week. Isn't that interesting? This one cut them short at 1 week, and they sued. Except in medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion on an unborn human being if the probably, that's probably my typo, The probable gestational age of the unborn human being has been determined to be greater than 15 weeks. So they passed a 15-week bill, and this was repugnant to the pro-abortion people in Mississippi, probably across the country, well, I'm sure across the country, and at Jackson Health Center, which became the prize for this fight, this prize fight. Note, it bans abortion except in certain circumstances, and that's when the state says it's allowable. And note also that it's based on not a judicial process, not a medical process, not a religious process, but a political process where sides negotiate and persuade, and they do so on deeply held beliefs or political strategy. Sometimes there are those who are really committed to a cause. They really don't care about the political outcome. And then there's the others who always evaluate the political calculus. If we pass this, then what? If we pass this, then what? Which I think, by the way, is the issue with which we're going to have to deal now going forward for at least a couple generations. The plaintiff in the case, or the accused, let's see, how does that work? The plaintiff was Jackson. The defendant was listed as Dobbs, Thomas E. Dobbs, who was the state health officer of the Mississippi Department of Health and infectious disease physician, board certified in internal medicine and infectious disease. And he had been district health officer and state epidemiologist. So here's the thing I understand about Mr. Dobbs. It wasn't necessarily that he was a super, pro-life advocate as he was in the position at the time when this went forward, and he caught the case. Now, he may be, I've never met the man, never talked to him. I haven't read a lot about him. He may be a real strong pro-lifer, but at least he took seriously his responsibility to defend the case. And he's, and also an associate professor at the University of Mississippi Medical School. Now let's look at the clinic. And the clinic and its services, this is right from their website, at least it was. Jackson Women's Health Organization, JHU, or would that be Yahoo? JHU offers affordable abortion care to women living in Mississippi and or traveling to the state of Mississippi. That's from their website. We are the only abortion clinic in the state of Minnesota, and I must say now were, because they closed on July 7th, 2022. Now you know the parties. We're going to cut to the chase. We're not going to spend a lot of time on background. Believe me, I'd love to. But let's cut to the chase, and that's its finding. It's expressed at the beginning of the decision, and it's summarized at the end. The justices said, we hold that Roe and Casey, Roe v. Wade, the 1973 decision, Casey 19 years later, must be overruled. That is profound, astonishing, incredible, unexpected by me and many who were hopeful. The Constitution, listen to this now. This is so key. The Constitution makes no reference to abortion. The Constitution makes no reference to abortion. We call that enumerated powers. There are no enumerated powers in the Constitution dealing with abortion. There are no enumerated rights in the Bill of Rights or any other amendments or anywhere having to do with abortion. Plain spoken. And no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly reply, the Due Process Clause of the 14th Amendment. So they're saying due process is denied to a woman who wants to have abortion because the law won't let her even consider it. Well, it goes deeper than that. And they're saying, it's not going to cut the mustard. So at the end, they restate what they stated at the beginning. We end this opinion where we began. Abortion presents a profound moral question. Oh, does it? It's about human life. Yeah, I would think so. The Constitution does not prohibit the citizens. This is very, very important. Does not prohibit the citizens of each state from regulating or prohibiting abortion. Regulating is different from prohibiting. Roe and Casey arrogated that authority. And what they mean is the states, and we'll see this later, were debating what to do about abortion. And all of a sudden, here comes Roe. Boom, it's gone. The federal government took it over with that decision. And Casey just made it worse. We now overrule those decisions and return that authority to the people and their elected representatives. Now pay a good deal of attention to that. Authority to the people and their elected representatives. It was not given to some higher authority, but to the people and their representatives. So, sending it back to the states. It is the time to heed the Constitution, amen, and return the issue of abortion to the people's elected representatives. Pay close attention to that. The permissibility of abortion and the limitations upon it are to be resolved like most important questions of our democracy. We have a republic, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. By citizens trying to persuade one another and then voting. I'm going to say something later on. I'll just touch on it right now. Imagine if the Supreme Court had said such a thing in the 1860s about slavery. Just imagine. Okay, just imagine. Now, talks about SCOTUS, the Supreme Court of the United States, as unelected legislature. There's several interesting constitutional applications from this decision by which they made their decision. So first of all, they said there's no constitutional basis for Roe. This is a critical comment, considering how the courts functioned for decades. And what do I mean by that? What I mean by that is ever since positive law or other forms of judicial undermining began, even into the 1850s and there somewhere around there, and then onward, the court has insinuated its own opinion into its decisions. And so to say that there was no constitutional basis, that's pretty critical, because the court had thrown that out and used other means of deciding. Why Ruth Bader Ginsburg and probably others even quoted a foreign court, a European court, in one of their decisions as a basis for how they decided an American jurisprudence issue. So enumerated powers limit the government's reach, except when the court says otherwise. That's the way it's been. And the enumerated powers in the Constitution tell the government what it can and cannot do. It doesn't tell you and I what we can and cannot do, and we've gotten that backwards for a long time. So this one is setting that aside and sort of returning that. Constitution, the Constitution itself is silent on abortion. You don't find the word anywhere in there. You don't find reproductive rights. You don't find health care. You don't find any of that. But the culture at the time was not silent. Even the culture in the 60s was not silent about abortion. There was a lot of debate going on about abortion at the time. Certainly, the culture at the founding of the nation was very clear, which the court is going to point out later on. So in issuing Roe and Casey, the Supreme Court says that its previous court had acted as a legislative body instead of interpreting the law. They were making up the law, and not only making it up, but issuing regulations, as you saw in Roe v. Wade, where they said you could have abortions up to a certain time, but then you couldn't, and then except under these circumstances. That's the way laws are written, not the way courts should be interpreting it. Justin Byron White called it an exercise of raw judicial power. And I throw this in a little bit because I write a lot about healthcare. In 2012, there was a case called NFIB Sibelius, and you might recall the Affordable Care Act required everybody to buy health insurance. The law said you must. Well, I can tell you there is no enumerated power whatsoever in the Constitution, if you read the plain reading, where the federal government could tell us that we must buy anything, especially buy something that is too expensive that we don't want and we hope we never use. But Congress had done that. And so that was the case. Part of what was being tried in NFIB v. Sebelius. The broccoli comment comes from a judge in Florida who said if they can force us to buy health insurance, they can force us to buy anything, even broccoli. And of course, he thought that was pretty funny, and so did I. As it was, the court ruled that it wasn't about mandating this behavior, but it was about Congress's power to tax, even though Congress had specifically said in NFIB, as they wrote the law, that this was not a tax. That was a case of judicial activism taking on itself a role that wasn't there, rewriting the law so that it could come up with a decision. Why that happened, it was 5-4. Justice Roberts was the swing vote. We don't still really know why. So this particular decision, there were actually 3 rulings. First, that states may or are able to regulate abortions for their states. What's a state? A state is a place where people live and citizens live and residents live, and they elect representatives in our republic to go and represent their views, and then they have the power, because they were elected by the people, to regulate abortions for their state. This was turning back the clock to the 1960s before Roe v. Wade, when states did regulate, and they were having the debate. You're going to see some statistics on that in a bit. So Mississippi is allowed to, this second part, regulate abortions for Mississippi, and that includes banning abortion after the 15th week of gestation. That's an act, and they can act in protecting the life of the unborn. That's what the court said. This is a state issue. It's not a federal issue. Why isn't it a federal issue? Because there's nowhere in the federal Constitution that deals with this. Back to the states. Third, it said, of course, Roe v. Wade and Planned Parenthood v. Casey were overturned because they arrogated the right of states to regulate abortion. And that is a state's issue, not a federal issue. All right? That's what they said. See why I like this decision? What Casey suggested 19 years after Roe v. Wade, when it quoted Roe v. Wade as a precedent, and some started using the term super precedent, by the way, and the court rejected that term. There is no such thing as a super precedent. It's made up. Okay, Casey suggested, that the controlling opinion in Casey urged Americans to end their dispute and accept the court's decision as final. In other words, think of the audacity of that. The court says, we're going to legislate in Roe v. Wade about abortion. Casey's moderating it a bit, modified it a bit, and then Casey's going to say, now, this is settled. Everybody go home. This is over. Unbelievable. Nothing's ever over in our republic. We can debate anything endlessly, and we do. But certainly not the abortion question wasn't over. So what did it not establish? First of all, it did not base the decision on something other than politics. It did not base the decision on something above politics. That means that abortion today, tomorrow, next year, for decades, probably in some states, if not all, is going to be a political issue. That means that unborn children will get protection in some states, but not in others. And then with interstate commerce and all of those clauses, people will be able to travel to other states that do not ban abortion and become, as California announces that it intends to be, if the voters still let that stand after time, and that's a destination place. And it's not just California. I'll show you another one in a minute. Where it'll become an industry, and a state abortion chambers established to offer abortions for tourists coming in, stay in Palm Springs, get your abortion, sit by the pool and heal. You know, I'm sorry that's cynical, but that I know something about medical tourism. That's the way it works. Okay. But it's all going to be politics. So let's go back to the Declaration where it says we hold these truths to be self-evident, that all men are created equal, that they're endowed, are created equal. They're endowed by their Creator with what? Certain unalienable rights, rights that cannot be taken away. Among these are life, liberty, and the pursuit of happiness. If you don't have life, you cannot have liberty and you cannot pursue happiness. That simple fact was impressed on me by a Democrat pro-life friend of mine in 1978 when all I was worried about was taxes and regulations on my business. And he said, David, without life, what else do you have? So this is what the founders were talking about. And the common law, which I believe we'll talk a little bit about before we're done here, government's unalienable rights have their root in creation, not in a constitution. They are not subject to politics. Constitutions cannot grant rights, nor can they take them away, except if they're doing it as an unconstitutional act. Now, we have a Bill of Rights that lists rights, but they were very careful to say these are not an exhausted list of the rights. These are some of the rights. In fact, they feared that courts would say because they have listed some, they would assume that there were no others. Guess what? Courts did that, still do. We need to work on that. So the rights come from creation, from God, from nature. That was our form of government. That was our worldview at the time it was written. And the purpose of government is to protect unalienable rights, not grant them. That is really profound. We get that out of this decision. That's what's exciting about this. We can find all that in this decision. But the court instead did rule it's a political issue, and they say properly addressed by the states, which means some states will ban abortions. Many had trigger laws that immediately went into effect. Some are in courts right now where the judges are confused and trying to rule against it. Those maybe eventually will roll up to the Supreme Court and they'll keep slapping them down. Some will apply rigorous regulations right down to no abortion except for life, probably the life of the mother in some, maybe one case, possibly, I suppose, or rape or incest. We could talk about that. This really isn't a talk about human life. It's more about the court case, okay? Some will choose very loose regulations, and then some will make sure abortions are legal. And now this is being made actually on election day. We don't know how this will come out. But in Minnesota, folks said, we have a guaranteed right to abortion because it's in the Constitution. I'm going to address that in just a minute. Maybe some will even allow abortions after a child is born, as Virginia talked about doing, as Dr. Peter Singer talked about doing. Dr. Singer talked about letting babies be born, and then folks can decide whether they want to keep them. Really sick, in my opinion. Okay, how can you do that? We ought to be protecting human life, all human life. So in Minnesota, my state, our Attorney General, as of today, has said Minnesota will be a destination state. That means medical tourism for abortions. That's what Keith Ellison said. And he's not talking about the Mall of America here. He's talking about abortuaries. And why? Why can he say that? Why do people say that about Minnesota? Why are they saying it in other states? Why are they bringing lawsuits to say that there's a right to abortion in the state constitution when there is no enumerated power, there is no mention, there is no right mentioned? In Minnesota, there was a case called Doe v. Gomez. I remember talking about this in the mid-90s. This was a 95 decision. It is the result of the Attorney General at the time stipulating that there was a right to abortion in the Minnesota Constitution. I am here to tell you there is no such right. He wasn't the only one. Doe was a fictional character. There was no Doe, at least by the time they went to court. And the case was about funding abortions for medical assistance, as we call Medicaid in Minnesota. Up until that time, even with Democrat and Republican legislature voting in a bipartisan way, they did not fund abortions until Doe v. Gomez, Supreme Court decision, wrongfully decided, said they must. And so how does that change? Well, it changes through politics. In Minnesota, at least, where we elect judges, it means electing other judges and making abortion, if you're pro-life, making abortion an issue. If you're pro-abortion, making sure that no pro-life judge ever gets elected. In Minnesota, I don't know about your state, but in Minnesota, judges have to retire by age 70. Of course, there's other judges that quit earlier. And usually it's in the middle of an elective cycle, and the governor appoints the replacement. That happens here all the time. In fact, maybe in most cases. One of my good friends turned 70 last December, and he had to retire from the court. The governor of the state appoints his replacement. The governor of this state is pro-abortion. Who would he pick? So you see what we're up against. You have to change the people who are in the office, because they will not rule on the constitutional issue. They will rule on the precedent that Doe v. Gomez alleges to have set. Until you change that balance, you cannot change the decision. Someday it will happen. What about your state? I don't know enough about other states to answer that question. So SCOTUS discusses several things in here that I just want to touch on briefly as a teacher, because I think it's pretty exciting. We're talking about federalism and states' rights, the fact that the federal government, the national government, has certain responsibilities, and states have certain responsibilities, and states are different. They're unique. They set their own laws. And I know a lot of people are not comfortable with that, but you know what? People who live in Mississippi are different from people in Vermont, are different from people in Minnesota. We're different from everybody. And so on and so forth. In California, well, you know, they're different too. I can't imagine how they can come up with a cohesive policy, but they do. Somehow, okay, federalism and states' rights. So that's a big deal. It's a reiteration of the Bill of Rights and its purpose. Its state, what it meant, what they meant, what they don't mean. It went into actually returning us back to the 1960s debate. I was in high school in 1965. I graduated, and I specifically remember the debates of those eras on abortion. And for the most part, at least in Minnesota, Republicans were pro-abortion. They were favoring a woman's right to abortion. And how that has switched, actually, because after Roe v. Wade, a bunch of Democrats came over to the Republican Party because they were getting more uncomfortable with their Democrat Party. And Republicans became a pro-life party. But we were having that debate in the 60s, and then here came Roe v. Wade and wiped out the debate. So a reassertion of states' rights, listen to this, so profound, could extend to a lot of other issues. It's not just abortion, but it could extend to many other issues in which states' rights have been arrogated by federal courts, not just the Supreme Court, but federal courts. My goodness, just think how profound that could be. But it does depend on state election politics and legislative action and a governor's signature. We don't know, as I'm doing this, who's going to end up as governor of Minnesota or attorney general or controlling the legislature. But if it did happen that there was a pro-life legislature and governor, or even just pro-life legislature, they could pass pro-life legislation, even if it keeps getting shot down by the court, with the hopes that someday it's going to get to the right court, based on who shows up and who's best at organizing. That's the way politics works. The reason that people get elected is not because they're really nice people who put their name in and worked really hard. It's because they are good candidates, not always nice people. They're good, motivated candidates who have a will for whatever reason to serve in office and are willing to put in the hard work and are surrounded by lots and lots of people who also want them to be elected and who organize. And so it is usually won, depending on demographics, by who shows up. These are not going to be based on principles of human life, except in the public arguments. They will be based on when I ran 4 times for the Minnesota legislature, I used to say I'm the best kept secret in the state because my campaign handlers would not let me talk about what I really wanted to talk about. They wanted me to be like a jar of toothpaste, tube of toothpaste, marketed as some commodity that people will love and vote for because they like my label or they like my sweet taste or whatever it is. I'm sorry, that sounds cynical. That's the way our politics work. And we're elected by those who show up. So the arguments may say abortion, but they use them to draw people to or from their cause or drive them from their opposition. I wish it wasn't that way. That doesn't mean that principled pro-life people can't run and win. Of course they can. In fact, if they're going to stick with it, they got to keep running on it. But okay. Whew. But not one bill is found. By the way, this is interesting. They mentioned what I'm giving you is actually from the decision, things that you can infer, imply, and take out exactly from the decision. They mentioned there wasn't a single bill to be found to ban contraception. And if it did, do you think it ever would get to the Supreme Court? They discuss rights, fetal life, unborn human life, and they say this is very, very interesting how it is different from any other right. And so using various stories, analogies, etc., to try to explain this right so the justices will change their mind is impossible because they believed that, and do believe, and I do too, that an unborn human life is a human life. And it is unlike any other right that we have, the right to life. They talk about stare decisis, which is precedence. And the court said this is very profound. If it's rooted in unconstitutional decisions, then it can't continue to have standing. And abortion is not supported by other precedents. There is no precedent for abortion anywhere in our traditions, our history, except since Roe v. Wade. And so that's what the court said. We stick with precedent, but those precedents that are rooted in unconstitutional decisions, you can't continue to go by that. My goodness, if we did, there would still be sanctioned discrimination based on skin color in our laws. They would have had to have upheld previous decisions just because the court made them. No, it doesn't work that way. The court every once in a while will overturn precedents, and it's a good thing. They also talked about the due process clause of the 14th Amendment, and they said that argument doesn't stand because it's got to be rooted in our history and tradition. You can't just say, well, this is due process. Well, no, if it's never been before, how can you make that claim? And so they did a lot of talk about common law. This is pretty interesting because the court went back into about the 13th century or 14th century in common law, arguing about when is a baby, death of a baby homicide if it's induced. And I'm not going to get into a big, long discussion about that either. A treatise on human life by Dr. Harold Kletchka, if you want a really good discussion on it. I edited and published that book a long time ago. I should have a picture of it up here. But Dr. Kletchka could actually track the whole abortion decision back to the 5th and 4th century in the common law, in which it was always treated as homicide. Even before quickening, there was punishment. And it was very clear anybody who brought an abortion upon a woman was guilty. They're guilty of homicide. That's our history and tradition. That's not part of anything rooted in American history and tradition. And 3/4 of the states, they said, at adoption of Roe v. Wade. No. Yeah. Oh, at the adoption of the Constitution. So, my bad. 3/4 of the states at the adoption of the Constitution made abortion a crime at all stages of pregnancy. So what is the history and tradition of abortion? How could the court then say that there was such a history? They went into the right to privacy in Casey's modification, where Roe expresses a feeling that it's expressed in the 14th Amendment. And then they stitch it together with other feelings. This isn't about feelings. This is about law. So before Roe, when state politics determined abortion laws, 30 states prohibited abortion at all stages, 30 of all of them. A third had liberalized their laws, and Roe had stopped that process, just put a break on it. So 30 states, Minnesota being among them. Minnesota was, if I remember correctly, was debating liberalizing its laws, but they hadn't done it. So when Roe is issued, it just puts a break on all of that and creates this huge chasm in our politics. And think about that. Think of the struggles. I'm going to tell you something that's kind of a strange little aside, but a good friend of mine, Denny Nowinski, was a very active union guy, pro-lifer, who taught me how important the pro-life cause was in 1978. When I ran for the legislature, he quietly supported me because he was still a Democrat. And then eventually in 1968, he ran for office as a Republican. And so he, a union conservative pro-lifer, came over into the Republican Party along with lots and lots of others like him. And would you believe they actually passed a pro-union plank in the Republican Party? My point is that Roe v. Wade had profound impact on the Republican Party and the Democrat Party, taking the pro-lifers out of the Democrat Party, if you will, the values voters, and bringing them into the Republican Party. And look at the chasm you have today. So what would have happened without Roe? I think there would have probably remained a significant union conservative, delegation in the Democrat Party, just as there was. What would have changed that? And the Republican Party may have been, the libertarian conservative big money party that everybody says it was. I don't know. You can't really know, but it caused this realignment. Now, the question is what's going to happen today after 50 years of Roe v. Wade, when all of a sudden, wow, how is that going to realign? I don't have the answer. I just have the question. Now, we're almost done, by the way, but the Dobbs decision identified three different groups that would react to this decision. First of all, there would be a group that have deeply held moral convictions about the origins of life with God as creator. I would be in that group. A personal responsibility to protect and advocate for life. Those of us are the ones that would believe in a deeply held moral conviction. One of our founders, John Adams, said our form of government is fit only for a moral and religious people. And it can't stand among any others. That was a paraphrase. I believe that. Then there's a group who have an emotional investment in keeping abortion legal, even expanding it. And they feel it's a civil right and it's about controlling their own body. So they have feelings, really strong feelings about this. And then there's a group they call the thinkers. So you have believe, feel, and think. People who reason that life should be protected, but they rationalize the meaning of law because they don't ever want a law that's black and white because that might cause somebody pain, so as not to offend those who disagree. So maybe they don't want to be bothered. And this group, the thinkers, are supposedly the ones who are the voting bloc that people think we have to appeal to all the time, not the believers and feelers. The believers and feelers are the ones who will turn out and support candidates, put up yard signs and everything else, so certainly vote. The thinkers are going to go back and forth, and the cycle's going to change. So what do we do now? Well, I think you recognize that this is a political process. You accept that fact and you organize toward it, maintaining your allegiance to those who hold the same position as you and will fight for it. when it comes to scrutinizing candidates, you want to carefully scrutinize them, not just say, well, because he's a Republican or a Democrat or a Libertarian or she's this or she's that, I'm going to support them. You really need to get as good a clear answer as you can. And those who equivocate, nail them to the wall and then get them elected. Got to get them elected. If they're not elected, there's not a lot of good they can do. And then ride herd on them. I know in my own teaching on this, should the majority change and become more pro-life, that we can't let them get by saying, well, Dovey Gomez, I'm saying just Minnesota right now, Dovey Gomez gives the right to abortion. No, it's not good enough. You start passing those laws that will provide reasonable regulation of abortion in the state of Minnesota, the ones the judge shot down. That's a good place to start. And maybe you can inch toward a 15-week or even something less than that as medical progress continues on. But ride herd on them. Don't let them off the hook, even if they have leaders or a governor who might veto it, or they think the court's going to shoot it down. So what? Do it again, do it again, do it again. That's the way you make law. So what do we do next? Well, we start in St. Paul by changing the mix there, by putting people into office and pressuring them to regulate abortion in a way that protects human life. That's my formula. Now, this is the big question, and you have to think about it. You may or may not know that one of my best friends in life and politics is Dr. Alan Keyes. Alan Keyes, the first Black Republican to run for president of the United States as a Republican. I was his national campaign manager. Dr. Keyes talks about human life somewhat in the same terms as he does about slavery. He is a descendant of slaves, by the way. And he would say, do you really want to trust the states on this decision? And I'm not going to answer that, maybe because I'm a little bit of a chicken, but I think that's a question that has to be debated. Is there a time and place coming where there does have to be a human life amendment for the same reason that we have the 13th Amendment and the 15th Amendment and the civil rights laws and all the other things that we have done to try to give protection to minorities, former slaves, and people like that? We certainly have to have that discussion. And we pray, and we pray, and we pray, and we pray, and we pray. And we ask God to forgive us. And we educate, and we persuade, and we do it patiently. In my opinion, changing the law in Minnesota, if we don't go to a federal constitutional change, which is going to be really hard to do, is going to take 40 years maybe. But meanwhile, we have to talk about it. We have to talk about life. We have to talk about the value. We have to talk about the Constitution. This Constitution that we have is quite a marvelous document, and it's withstood so much. If we can get back to interpreting the Constitution based on original intent and informed by the principles found in the Declaration of Independence and in the writings of the founders and the worldview of the founders, so that we can understand what they really meant, then we can decide what we want to change, if we want to change something, and we can decide what is of premier value, and we can get back to being a people of liberty and freedom who cherish the unalienable life to life, a gift of life, liberty, and the pursuit of happiness. I believe that's true. I expect you have a lot of questions which you can't ask to a recorded program. But you can email me, you can contact me, you can go to daveracer.com. You can send me an email at dave@daveracer.com, and we'll talk about it. I think, and you could probably tell that I'm a bit passionate about this teaching, and I think it is just so profound, and what a great thing to happen. My goodness, I'm an elder. Okay, I'll tell you, I'm 75 years old. I was there when Roe happened. I'm here when Dobbs happened, and a lot of people. That's doesn't make me special. It's just makes me fortunate. And there's been times I've despaired of our nation, whether we can ever succeed. I'm still not sure. But I do know that with this hanging over us and our made-up Constitution changing at the whim of everybody, that we could never sustain ourselves. And so I'm grateful for the decision. I'm grateful that you took this lesson, and I hope to see you around.